So many people move from one state to another nowadays. Maybe they want to be closer to family. Maybe they're moving for the weather. Maybe they have jobs that they're moving to. There's a whole lot of reasons. But estate planning laws are state specific. They're different for each state. So if you're thinking about moving or you know somebody else who is, then this video is for you. So here in the Bay Area in California, we have a lot of people who've moved from different states or even different countries for a lot of the engineering jobs that are here or other service industry jobs. And also because we have such amazing weather. Right now, when I'm recording this in mid-August, it's in the high 70s right now with no humidity. I mean, not many states can say that. So what if you recently moved to California? Do you need to redo your estate plan? Well, it depends. As long as a trust has been created in the United States, it should be valid in all 50 states. But it might not work correctly in a state other than the state that it was created for. I want to give you two examples of estate planning differences that you can find between the states. So first of all, California is what we call a community property state. So when you're married and you're earning money, that money that you earn belongs to both spouses. This was created to protect the at-home spouse, the person who might be raising kids or taking care of the house. They own that money as well. There's 8 other states in the United States that also have community property regimes, in addition to California. Those are Arizona, Idaho, Nevada, Louisiana, New Mexico, Texas, Washington, and Wisconsin. So if you didn't hear one of those states that I just listed off, you are not in a community property state. And so that means if you're married and you move to California, your trust will not talk about community property and how it's to be handled. Well, this is a problem because upon the first death, we really need to see where does the community property go upon your death. So you'll likely have to have your trust redone to address this community property issue. Now, when I say you might need to redo your trust, does that mean you throw it away? Well, in some cases you don't need to. You can actually keep your trust with the name the same, and you can do what we call a restatement and amendment, where we update all the insides of the trust, but you keep the title of the trust the same. So that means you don't have to retitle your bank and brokerage accounts, the assets that, like your real property assets that are held and titled in your trust. You don't have to redo those. Now, I do want to mention, if you've earned money in a different state that doesn't have a community property regime, and then you move to California, we consider that money that you earned in another state quasi-community property. So that basically means it would have counted as community property if that state had community property laws. So if you ever see in a document quasi-community property, that's what it's talking about.
Hey everyone! If you like my mom's video, like and subscribe.
Now there are some states that often do reciprocal trusts. That means for a married couple, one person would do a trust just for themselves and leave everything to the spouse. And then the other spouse would do their own trust and leave everything to the first spouse. I'm not sure why they do that. I know in New York, this can be a popular practice. I don't know why, because I don't practice in New York. But I have had clients move to California from New York and we just start over. We don't do that type of planning here in California. There could be good reasons for it. I don't know. The other thing to be aware of is that public benefits laws are different in every state, okay? Here in California, we are quite generous with our public benefits in comparison to many other states. And I actually discuss this in many of my videos. There's one video that I have that's called Medi-Cal Updates for 2024. And you can see how Medi-Cal and its eligibility is treated very differently here in California than in any other state in the country. So if you've prepared a special needs trust for a loved one in a different state and that loved one lives in California, that trust might be too restrictive for the child. You might need to redo it. I want to actually give you a specific example that I ran into once. Here in California, we can put in a trust that a trustee or a trust protector has the ability to modify or change the terms of the trust if there are laws that are passed that would otherwise render that special needs trust invalid. Now, in other states, like I understand in Texas, you're not allowed to put in this language. You can't have somebody make modifications to an irrevocable trust if there's changes to the trust law. That would invalidate the entire trust. So you really do have to be careful when you're looking at special needs trusts in particular to see, okay, where does the beneficiary live? And make sure that you're designing the trust to match the laws where the beneficiary lives. So let me give you an example. If you have parents, like my parents, they live in Pennsylvania, but if they have a child or a grandchild who lives in California and they need to do a special needs trust in California, then my parents should hire an attorney like me in California to do a California special needs trust for the beneficiary who lives in California. Now let's reverse it. Let's say that I live in California and I have a special needs child who lives in Massachusetts. Then would a California attorney do the special needs trust for the child who lives in Massachusetts? No, the California residents should do their own revocable trust here, but then they would hire a Massachusetts attorney to do the special needs trust for the child in Massachusetts to make sure that it matches Massachusetts public benefits laws. Now, I think that real property is the trickiest of them all. Real property laws are definitely different in different states. As a California attorney, I'm licensed to practice estate planning here in California, and I understand the laws here in California. So I can do a trust transfer deed, for example, for a property located in California. But I do have a lot of clients who own property in other states. Maybe it's a second home or a vacation home or a rental property. I will not do the deed to transfer their property, say in Nevada, into the California trust. Now, property in Nevada can be transferred into a California trust, but you have to use a licensed Nevada attorney to prepare the deed to transfer that property into the California trust and then to shepherd the deed through the recordation process. So I would often coordinate with an attorney in that other state, but it's the attorney in the other state who understands the laws of that state of how to get an asset into the trust. So those are just a few things to think about if and when you might move between states. If you're moving to California, I say, welcome to California. We would be so happy to help you with your estate plan. We can look over the trust, see what might need to be changed, and we can do either a restatement amendment or we can start over, depending on the type of trust. So I hope this is helpful and happy planning.
Hello everyone! If you liked my mom's video, don't forget to like and subscribe. See you all next time!